Don't sound. It is high time we discuss in terms of the temporary injunction. Oh my God. Let's start the discussion on point of temporary injunction. And order 92. Oh my God. 39. Maybe 39. Order. What exactly the thematic approach? Please, let's have a look here. We have to actually discuss in terms of temporary injunction. Well, Mr. Sharif, we have to actually discuss in terms of temporary injunction. So how can we actually discuss? Let's have a look here. This is the systematic way through which you can easily understand or discuss major temporary injunction. The discussion on point of temporary injunction. Okay, no one is watching this video. Mr. Oh my God, Mr. Riyadh assigned to me. Oh my God, no problem. Just the systematic way. Hearing system, please. Bhutan. Okay, 5 persons are watching this video. What an approach from the side of 5 persons here to the session on point of temporary injunction. So, first of all, we have to discuss totally what exactly the temporary injunction. What is the media and what are the systematic way how to discuss that? First of all, we have to actually discuss on point of the meaning. So what exactly the meaning? So the prelude or the preface. What exactly the thematic approach? The core point of this, Mr. Bhutan, you have to actually follow the instruction of mine. How to discuss? Just follow the instruction of mine, please. Preface, that can be termed as to the introduction, or the preface, or the prelude, or the starting movement. That should be prescribed here, the writing skill. And then what exactly the meaning of temporary injunction. And not only that, how can we actually discuss in terms of that? And whereupon, this is the systematic way and this is the laws relating to the provision of laws. What are the laws which will be dealt in this regard? Provisions of laws. Please, let's have a look here. And then glaring example. What is the glaring example in this regard? And not only that, we have to focus in this regard. Please, let's have a look. Have you got what I delivered to you? This is temporary injunction. Temporary injunction. So now the question here is that the types that should be focused here. We all know there are 3 types of injunctions prevailing in our existing laws. Like this, the TPM. So what exactly the meaning of TPM here? What is the meaning of TPM here? The meaning of T represents the temporary injunction, and the P perpetual injunction, and M is mandatory injunction. According to the SR Act, you know, this is the SR Act 1977 maybe, and the section 52 to 57. And a section, but the temporary injunction is administered from the side of the CPC, the Code of Civil Procedure 1908, maybe. So the TPM prescribes that in such way. Now the question here is example and then establish case law or the provision of laws, and not only that's the grounds. What exactly the grounds through which the temporary injunction may be applied before the code of law. So what are the grounds of that very term? And not only that the grounds, and not only that the exception. So what are the exceptions in this regard? And not only that's the leading case law, or that can be termed as to the landmark decisions. landmark decision. What exactly the meaning of landmark decision? You have already know. And the concluding remarks. That's the conclusion. So conclusion will be treated here. So those are the points. Those you can easily discuss in terms of the temporary injunction. Mr. Burton, have you understood? Have you comprehended that? Whether yes or not? Yes. So to discuss regarding the temporary injunction, we have to actually follow that instruction. First of all, you have to follow the preface. What exactly the preface? Which will be written from the side of the Black Law Dictionary edition 8 page number. What exactly the page number in this regard? This book is prescribed in such way. Mr. Boetian, have you heard the name of that very book? So in this book, it is quite clear to us what exactly the temporary injunction and what is the edition of Black Law Dictionary that can be focused here. And not only that, yeah, this is the preface. So what exactly the meaning of preface? You have all know that the introduction. So what is the simplicity in this regard, the introduction? And not only that, the meaning. What is the meaning of that very concept and the definition of temporary injunction and the provision of laws prescribe that and the granting example in this regard. But unfortunately, the provision of laws in this regard, you have all know under section 94 and 95 and what exactly the water 30, this is Water 39, you of all know in this regard, 39, and rule 1, what exactly the rule 1, 2, what exactly the thematic approach rule 7, maybe you have to rule 1 to 7, that should be discussed here. And 95 prescribes that 10,000 DHAKA will be needed in this regard, whether yes or not. This is totally vague in idea. This is not elucidated neither. And not only that, so what exactly the grounds may arise from that temporary injunction, that should be focused here. And not on the exceptional case and the landmark decision and the concluding remarks. Now the discussion made in terms of, first of all, we have to focus in terms of the provision of laws. But to go through the provision of laws, we have to go through the landmark decision to what exactly the grounds, exactly. What are the grounds to which temporary injunction will be applied here? So here is the ground, please. Let's have a look here. Having systematic, please, let's have a look here. So what are the grounds exactly in this regard? The leading case law in this regard, talk about the leading case law. So what are the grounds? Those are not mentioned under Rule 39 of the CPC or the Code of Civil Procedure 1908. Just the case law prescribed in this regard, the landmark case laws of Dalpat Kumar. Oh my God, what a case law. Please, let's have a look. Dalpat, oh my God, Dalpat Kumar. This is the landmark decision. Dalpat Kumar and another, oh my God. Please, let's have a look. Where from the grounds may be arise to be for you to understand in terms of the temporary injunction. Dalpat Kumar and another versus the case law, that's the, oh my God, Pralhad Singh and others. Pralhad Singh. What exactly the Pralhad Singh and others. This is the case law. And the citation 1991. Oh my God, 1991. So why it is quite clear to us what are the grounds of applying temporary injunction. That should be prescribed here. Please, what are the discussed media? Please, let's have a look here. Mr. Boetian, have you understood what I actually delivered to you? If you are not able to discuss, able to comprehend the lecture of mine, then follow the instruction of mine. Just what is happening from the side of law doctor to you. So this is the landmark case law. This is the 1991. Yes. So what are the grounds of temporary injunction? First of all, the grounds number one, here is the prima facie case. What exactly the prima facie case? Have you any idea, please? Prima facie case. Prima facie case. So this is the only one number grounds. And ground 2. So what exactly the meaning of prima facie case? This is this means that a lawsuit that must be serious and a disputed caution for the temporal injunction and sufficiency. Do you have any idea in regarding the prima facie case? No? Just go through the lecture sheet from the side of law doctor. Just comprehend that. And the second one, so what exactly the grounds? Second one is irreparable loss. What exactly the irreparable? Oh my God. Irreparable loss. Oh my God. Who actually loses his or her property? In time of that, in the situational cases, in what exactly the temporary injunction, there is no one is able to grab. Oh my God. Yasin. Oh my God. Amir Ali. Oh my God. SM Ghulam Kibriya is watching with me. So how dare you? This is the systematic way. No one is able to understand the language of mine. So, and several times I have focused in this regard. Jati Manush Chinlona. So, let's have a look here, Mr. Brethren. The third number provision in this regard, what exactly? This is the balance of convenience. So, what exactly the balance? Balance of convenience. So convenience means the balancing power, exactly. Those are the grounds of applying the temporary injunction before the court of law. So this is the fucking approach from the side of law doctor. Whether yes or not, we're not able to discuss entangled terms, and that's why several times what is students of law, the professor of laws, and the fucking advocates in our Supreme Court like Mr. Mabuddin Kakan and Will could discuss maybe prescribe in this way. They've answered that how to answer and how to compare with Mr. Shafiq Nasr from the side of law doctor. This is the fucking approach. So no problem. Mr. Juvaraj Mizan is watching this video. How do you? And Shafiq, oh my God, Rafiqul Islam is watching with me. The students of Law Academy. So they have no concept at all to understand, to comprehend that the nature of discussed matter. The first of all, what I discussed regarding the prima facie case. Please, Mr. Bhutan, have you any idea in terms of the prima facie case? We are selling Mr. Wulkud the schedule. Oh, answer. This is the fucking approach. We are whether we are actually selling him or not. They have no concept, and he has no concept. He is the child of law. He has a knowledge, of course, knowledge in law, but there is no option to prescribe in terms of knowledge of law. So there is a distinction between the two in and of. So let's have a look here. Mr. Bhutan. So this is the ground. The first number ground prescribes that the prima facie case. Please study. And graphs, not only graphing power. Just you have to go through the instruction of law doctor. And focusing power as you are going to be a barrister in future life. The fucking barrister in our country. You have no knowledge at all. This is the bitter truth in our country. So the prima facie case prescribes thus. This is the number one ground to apply before the court of law. So why from this is the systematic way? Maybe arise Dalpat Kumar and another versus Pralhad Singh and others 1991. This is the case law where from we have the three grounds of the temporary injunction. Well, the number two, this is the irreparable loss. So what exactly the irreparable loss? We have no knowledge at all. Rafiqul Islam and SM Ghulam Kibriya. And Amir Ali, Mr. Amir Ali, oh my God, he prescribes data splendid. How dare you? How dare you? You have already written this is the splendid in nature. This is the fucking approach. And not only that's the balance of convenience. That the third number grounds, which will be prescribed from the side of the Dalpat Kumar and another versus Pralhad Singh and others. This is the case law. If you are the students of law and you are going to sit bar council exam, we are selling Mr. Ruhul Kudus. What a fucking approach in our country. Oh my God, this is the fucking approach in our country. Not the This is the systematic way. So the prima facie case prescribes that this is number one ground, and second was irreparable loss, and not on the balance of companions. Now the question may arise, what from this is the grounds we have to actually scrutinize that whether the defendant is able to get this opportunity or this remedy from the side of the CPC. Mr. Burton, this is not the fucking approach, and several times I have focused that jati manush chinlo na. Kotin bade ami putrikar headline hobo. I will be the headline of the newspaper, but you have no concept at all, mister. You have no concept, and that's why you are going to approach in such a way. This is not the exact thinking level from the side of Dalpat Kumar and another versus Prahlad Singh and others. What from we have already got 3 grounds. This is quite clear to you. This is the Dalpat Kumar and another versus Prahlad Singh and others, 1991. Oh my God. What approach from the Yasin? Oh my God. Yasin is watching this video. Rafiqul Islam is watching this video. This is the sham for the whole nation. Only maybe 3% are watching this video. And we are ignorant in our existing society. We can't challenge to all the whole world, America, Canada, USA, Russia. We have no ability, but we are showing you our approach towards the whole nation. That the fucking approach, mister. This is not totally true in nature. So this is the systematic way to discuss in this regard. Now the case law, landmark decision from the side of the Bangladeshi case law, or the BD case law. What exactly the BD case law in this regard? So several case laws in this regard. So why actually we have to focus in this regard? That should be prescribed here. So the first number one, you know, this is several case law which will be discussed and which discusses in this regard. But unfortunately, we have no idea at all. This is the Sheikh Ahmed and others versus Abdul Alim. So this is the case law, Sheikh Ahmed. So this is the another case law, Sheikh Ahmed and others. So you have already Bhutan, you have already, oh my God, mistaken in tagging this ORS. So this is stated and others. You know, this is Sheikh Ahmed and others versus what exactly the thematic approach versus Abdul Alim. So this is another case law, Abdul Alim case law. In this case, it is quite clear too, and this 1988, this is the old case law, wherefrom it is quite clear to us what exactly the temporary injunction. That should be remarked and that should be prescribed here. But unfortunately, the students of law and the professor of law and not only the fucking advocate from the side of Supreme Court, they have no concept at all to understand, to comprehend what is actually the happening movement, what is the fact of the case. There is no knowledge actually. There is a knowledge, of course, this is the what exactly the fact of the case and the issue arises, and not only the decision making power of the code, and this is not the reasoning or what exactly the reasoning systematic law. And not only that, the referred case law is not present in the memory or the CPU of a human being or the faculty, but they show their arrogance. I'm the advocate. Oh my God, I'm the advocate of Supreme Court. So this is not exactly until or unless they can't. Actually, the probing approach is not present in their CPU, and they are showing their arrogance towards the whole nation. And the ignorant people will accept that the grasping power. Oh my God. So this is the fucking approach in our country. They can't understand Jati Manush Chinlona. So this is the systematic way. For example, the fucking advocate in our country, like there's a naming advocate. So this is the already this is the systematic captain. This is the RQK. Oh my God! And this is the systematic way. So this is the fucking and the fucker advocate in our country. They have no knowledge at all. And this is the buying and selling system. Win and loss system may be occurred in our country. And not only that, what exactly the fact of the case, Sheikh Ahmed and others versus Abdul Alim, 1988, there is no concept at all. But they are showing arrogance and arrogant behavior will be treated from the side of productor. They have no concept at all. Oh my God, this is approaching power like the Awami League. We have to show like the Shibir. Systematic way. So this is the fact of the case and the what exactly the issue and decision making power and the reasoning system and referred case law. What exactly the referred case law? Several case law in this regard in forms of the temporary injunction. The another case law, Anwara Khatun. Oh my God. What exactly the Anwara Khatun? Oh my God. You have no actually knowledge and others. Mr. Boetian, you already mistaken in this others. This is not the organization. This is treated as to the others. And not only that's the verses. This is the case law. Oh my God, Gyashuddin Ahmed and others. Gyashuddin Ahmed. Oh my God. And others. This is another case law. But the arrogance may be occurred from the side of, oh my God, 1986. Oh, this is another rapid case law in terms of the temporary injunction. So what is the fact of the case? And the issue may arise, there is no knowledge at all, as you are the students of law. Yes, you are the students of Harvard, Cambridge, Oxford, not only in the RU or the Russian University or University of Russia. Maybe you are the students of University of DHAKA, Chattogram. No matter how high soever, you have no bill in our country. Until or unless you are pressing power proves that, oh my God, law is power. Exactly, law is power. Mr. Arif Abi, oh my God, Mr. Arif prescribes that law is power. So power is exact from the side of the Michel Foucault or the Foucault and the Laka Sahib from the side of the, oh my God, oh my God, oh my God. This is the Michel Foucault from the side of Mr. Arif and Laka Sahib has been discussed and Solimullah has several times prescribed in this regard exercising power in the world. Power in the institution, power in the state, or the country, power of the side of the BNP, Jamaat Shibir, Bal, what even maybe this exercising power, this is the world of power. To exercise power, we have to go through the instruction like this, that temporary injunction. But unfortunately, we have no knowledge. And they what me? In such a way, what are the grounds? Please let's have a look at the finishing moment. So several case law in this regard. That the finishing movement prescribed in this regard. Please let's have a look here. You have to actually watch. Here is the number one, please. Mr. Boetian. Yes, you have to follow the instruction of mine. Number one, let's have a look here. Number one, you have to follow the instruction like this, the temporary injunction. Whether yes or not, this is temporary injunction. But you have to actually follow the instruction preface. What exactly the preface here? And then the meaning, what that can be remarked in such a way, that's a definition. To understand that's a core point of a temporary injunction. But what is that zigzag? Oh my God, what is zigzag? In such a way that the zigzagging made they pose and they show arrogance. Oh, the arrogant behavior from the side of the others, but they have no any peace or what is the little knowledge in this regard. This is the parking approach. And not only that, the preface, after preface, we have to follow the instruction of provision of law. So what exactly the laws deals with this situational case? We have to follow, this is the SR Act deals in this regard, like 52 to 57, this is the systematic way. But unfortunately, the Warrant 39 prescribed and Rule 127 prescribed in this regard. And not only that, the temporary injunction will be administered from the side of the Code of Civil Procedure 1908. Whether yes or not, you have all know in this regard. And not only this, the 52 to 57, that can be dislikes in such a way. This is the TPM. What exactly the TPM, temporary injunction, perpetual, and the mandatory injunction. Now the question may arise before you, what are the grounds and what are the reasons and what are the main provision to which we can apply the temporary injunction, or the grounds and the perpetual injunction, or the mandatory injunction, whatever may be. So the question may arise, what are the grounds of that? And then exceptional cases, what are the landmark decision and the concluding remarks. Now the question may arise before you, what are the grounds and where from those grounds may be occurred. You all know that the grounds have been emerged from the Dalpat Kumar and another versus Pralhad Singh and others. 1991, this is the case law. Wherefrom we have already got three grounds. Number one grounds is prima facie case. Number two is irreparable loss. And that's number three is balance of companions. Those are the grounds. Just you have to focus in this regard. So where from those grounds may be occurred. This is quite clear to you. But unfortunately, this is the parking approach and the teaching method in our country. They have no at all. They have no knowledge in law. Of course, there is knowledge in law, but there is no knowledge of law. So what is the distinction between the two in versus of? From the side of, according to Mr. Shahriar Parvez. Mr. Shahriar Parvez, from the side of Russian University. So what is the distinction, or what is the difference between the two legs in and off? Mr. Bhutian. So, this is the Joined Islam LLB, but unfortunately we have no knowledge at all. Arif, Mister, you know about the Michel Foucault, Excellency, you have no Campia in law department. Oh my God, Mr. Arif, Michel Foucault. Yes, I have already studied the books of Michel Foucault, all the thematic approach from the side of Michel Foucault. So the points may be arised from the side of Dalpat Kumar and another versus Pralhad Singh and others. This is the case law. Yes, Mr. Bhutian. This is the case law. Wherefrom we have already got three grounds. Number one, prima facie case of the plaintiff, whether this is the defendant, no matter against the code, but there is immunity power in the administration of justice system. There is a systematic way in terms of against the code procedure or the cross proceeding. And not only that, the irreparable loss of the plaintiff or the defendant. And not only that's the balance of companions. Oh my God. Oh my God. Have you understood? Have you comprehended what I delivered to you? No one is able to actually compare what the law doctor is. There is no power to examine, test. There is no power to test or justify on point of law doctor towards the hakpak, towards the minipini, towards the, oh my God, bijuri. No matter how I say what, they have no concept at all. And that's why this is the fucking people in our country. They can't actually show their approaching power towards the whole nation. They have no power to challenge to USA, UK, Harvard, Cambridge, Oxford. No matter that's the DU or the RU or the TU. No matter how whatsoever, mister. This is the parking approach. So no one is able to grasp, comprehend the approaching power. Like this is this case law, Mr. Bhutian. This is the case law wherefrom we have catch, and we have already got three grounds. 3 points. Yeah, 3 points, Mr. 3 counts. Number one, prima facie case, irreparable loss, and the balance of convenience. That can be termed in such a way, Mr. Bhutian. Babe, oh my God. You have to focus in such a way, babe. Whether yes or not. What exactly the babe? P means prima facie case, I means irreparable loss, B means balance of convenience. Today's number. This is next. Baba. Mr. Bhutian, you have to discuss, please. Again, please. Come here. Come here and show the arrogance towards the Mr. Ruhul Quddus Kajul, towards the Mahabuddin Khokon, towards the Prime Minister. Oh my God, there is no option to Prime Minister in this regard. Husband will be flat. But you have to show your arrogance towards the whole nation, towards the Oxford, Cambridge, Harvard. Let's start, please.
Yes, sir.
Okay, let's start. And you discuss major in terms of how to discuss in this regard, please. Let's have a look here.
From the cases of Mandati Riganda.
Sir, from the cases of Mandati Riganda.
Okay. So, what the sir had been given or discussed in the previous issues, the temporary of injunctions. Temporary of injunctions. So, for that, according to the 3 points, now fact issues and the decisions and the reason and the landmark cases. Okay, for this, depending on the 3 cases, so I am taking a case. What should be going on the temporary of injunction? So, whatever I can take a box like that. So like that I'm taking. So I'm discussing whether with the case law. So taking the white pen. So this is the case law according to temporary injunction. Mandati Raganna. Mandati. Mandati. And this is the cases of temporary injunctions. Rangana versus what? V.T. So Ramachandra. So according to Mano or SC obligation 7567, the case was obligation 7567. Okay, the technical error occurs, whatever MANU. I am again writing SC obligations 7567, and the case was the year of 2008. Oh, it's disturbing, technical problem. Okay, fine, again I am writing Ramachandra. So Manu or obligations or SC or 7567, the case was 2008.
Just right. 2008. Yeah.
2008. So, according the court, what emphasized that when considering an application for the grant of temporary injunction in CPC, means Dandavidhi, it's not sufficient to only consider the fundamental Danda Karjavidhi, Devani Karjavidhi, CPC or CPRC Fauzdari Karjavidhi. Okay, it's not sufficient to only consider the fundamental elements such as the existence of a prism facie case. The second point discussed by the sir, temporary injunction. Second point of view, balance of convenience, that means the third point of view, and irreparable injury. So, granting an injunction is an equitable remedy, pratikar, and the court must also take into account the conduct of the parties involved, and specifically, what is the mandatory thing? If one party has remained silent, that means keeping silent, chup আছে, for an extended period at a নির্দিষ্ট সময়ের জন্য, and allowed another party to exclusively deal with a property, they may not be entitled to an injunction. তাহলে injunction entitled হচ্ছে না. The court will not intervene.
Usually the instruction from the side of Bengali language. But sometimes you have to discuss Jati Manush Chillona.
Because sir, always the person.
But you are not allowed to speak in Bengali. Okay. This is high time, and it is high time we discuss in terms of English terms for the time of. Okay, go. Okay. Let's go.
Thank you, sir.
And so no problem may occur in this regard. You are not allowed to sing approaching power like Mr. Dr. Yunus. You are watching in this situation like this, watching, oh my God, this is the Chief Justice. This is the fucking approach. What exactly the thematic approach? Abul Kalam Azad and another versus Musa Khatun. This is not the fucking approach. Just you follow the instruction of law doctor. Your hand, only this hand is in your hand, and you have to actually discuss on point of the temporary injunction. No matter any paper is not present in your, that blank paperless hand will be presented before the audience. Okay, mister?
Yes, sir.
As you are the IBA students, as you are the Vietian, and not only that, the law students from the side of the ideal law, what exactly law college? But we are from the Russia University. That is not the arrogance from the side of the RU. That is not the fucking approach from the side of you. Yes, you are the Ruhul Quddus. You are the Mr. Mahabuddin Khokon. You have Nobel. You have Nobel at all. In proportionately the case in terms of the law doctor, we are law doctors, and that's why you have to actually scrutinize in this regards that the hand, blank hand, and the marker, all the pen is your hand. That should be prescribing media. So what exactly the thematic of Manda and what exactly the Ramachan? So this is the 2008 or the 2008. This is the case law. What exactly the fact of the case? In such a way you have to discuss. What is the fact of the case? Just your blank hand should be discussed. This is not the hawk. This is not the minifini. This is not the inshika. This is not the what exactly dizuri pizuri. This is law doctor. You have to actually believe that. This is not the fucking approach from the side of law doctor to you. This is the fact and the what exactly the issue arised and the decision making power of the code, and not only that the reasoning systematic way. So what exactly the reasoning system that should be prescribed until or unless this is the fucking approach like Dizuri, like mini law, like Anshika. This is the fucking approach. This is the age of darkness. Like this, I am a China mister. You have to, oh my God, this is the approaching power. This is not the Amit Chahila. This is the enlightened society. This is not the new. Oh my God, this can be termed Renaissance. Oh my God, this is Renaissance. So the what are the grounds that should be prescribed here? What is the fact of the case? What is the issue and the decision making power? Yes, you are going to be a barrister. That can be termed. As to the barrister, you are going to be a barrister in future life. This is the fucking approach in our country. No one is allowed to use this term barrister in our country, in existing society, in existing laws. So, Mr. Wetton, you have to focus. Just follow the instruction of mine. So, no matter. Just we are discussing in this regard, what is temporary injunction? What is temporary injunction? Already we have focused in this regard. Today's no more. Today's no more. Bye-bye. Bye-bye.